exhibit is excludable for a couple of reasons. First, it is the opinions stated therein are not stated to a reasonable degree of scientific or medical certainty and therefore do not meet the requirements of the Tennessee Rules of Civil Procedure and Tennessee Rules of Evidence, so it should be excluded on that basis. In addition, the declaration itself contains information for which the declaration does not establish that the witness has the expertise with which to provide those opinions, and in fact is merely a recapitulation of the opinions of Dr. Joseph Antonini, and that's A-N-T-O-G-N-I, I believe, although he'll correct us later this afternoon if I'm wrong, which is improper bolstering of an expert witness. Dr. Lambrakos does not have any experience in pain management, anesthesia, or surgery, and so is not a witness who has the proper foundation to provide many of the opinions in her declaration. And so for those reasons, we move to strike those from the record. Obviously, these witnesses are going to testify live, and they can attempt to fix their problems on the witness stand. But as far as the record goes, we all know that there's a possibility that another court will look at whatever it is this court does. We want to make sure that the record complies with the Tennessee Rules of Evidence.
Thank you.
Thank you.
All right, on the other side.
Good morning, Your Honor.
Morning.
Briefly, as it relates to Dr. Antonini, counsel is correct. That was an oversight. We did submit this morning an updated declaration that does use the magic words under penalty of perjury. I think that settles that matter.
I agree.
As to Dr. Lambrakos, the very first page, paragraph 3, she states that her testimony is to a degree of medical certainty. Right on the first page on paragraph 3. As it relates to her qualifications, she'll be testifying Wednesday. For her declaration, she is the only expert proposed to testify in this particular hearing that is a cardiac electrophysiologist. This hearing is about an implantable ICD. She is the one who has the expertise to discuss how it works, when it works, and when it doesn't work. Excluding her testimony is simply would be an error. We believe that she is more than qualified, and she will show that on Wednesday when she testifies. And just so we're clear, she cites both the plaintiff's expert and the defense expert in her declaration as it relates to the effects of pentobarbital, and she is subject to cross-examination on whether her knowledge fits or not for that. But she is the only cardiac electrophysiologist that's going to testify in this hearing, which is what this case is about today.
What about the other objection as to particular paragraphs?
These are expert witnesses. Dr. Antonini has an opinion as to Dr. Van Norman's opinion. This is how that works. When experts have competing opinions, they are entitled to make an opinion regarding the expert on the other side. Dr. Van Norman is a very experienced anesthesiologist. Dr. Antonini is a very experienced anesthesiologist. They have been on opposite sides of these cases for years. They are entitled to make opinions regarding the other's opinion, and I'm sure Dr. Van Norman will be more than happy to respond to what Dr. Antonini's opinions are, and he will be subject to cross-examination regarding those opinions from counsel.
The motion is respectfully denied. The court reserves the right that if something is without proper foundation or it should not properly be considered, that the court may disregard it and let everybody know it, that the court is disregarding it. But at this point, I'm not striking it. So that's the court's ruling. Are we ready to proceed with the first witness?
Your Honor.
All right, go ahead.
Your Honor, plaintiff Fire Black calls Dr. Daniel Martell.
Your Honor, before we hear from Dr. Martell or any witness, I have a couple objections to the court. First, I think Your Honor needs to consider the objection to jurisdiction that the defendants have made to this court. The ability to stay in execution or set conditions on this execution that's set to happen on August 5th is exclusively within the province of the Tennessee Supreme Court, who just recently last week reaffirmed in its order on Mr. Black's competency appeal that by the order of March 3rd, the warden or his designee shall carry out the execution of Byron Lewis Black in accordance with Tennessee law on the 5th day of August, unless a stay is entered by this court or by a federal court. I think it'd be inviting error, Your Honor, for this court to even consider testimony on these motions or consider any of the evidence when the court lacks jurisdiction. So we would ask that this court address the jurisdictional issue at the threshold.
I respectfully conclude that I do have jurisdiction to hear this. Now, what relief, if any, I grant, that may be some jurisdictional boundaries to that. But to hear the proof, I can do that. So that's the court's ruling. There has not been a request on the part of plaintiffs to delay the execution. So we're here on what could be a narrow issue, but we'll see as to proof.
Your Honor, one final objection before I understand Ms. Henry wants to call Dr. Martell first. Dr. Martell, according to the declaration offered in support of the plaintiff's motion, has formed opinions about Mr. Black's competency to be executed. Each of the opinions that he has formed in declarations and supplemental declarations over the last 5 years relate to that standard of competency to be executed. That declaration was offered in support of the competency petition in the criminal court that did not survive threshold scrutiny and make it to an evidentiary hearing. His declarations don't purport to evaluate any of the issues in this case or in this motion. We think his testimony is irrelevant. We also think that his testimony ought to be excluded for the separate reason that Dr. Martell formed his opinions after having the opportunity to evaluate and examine Mr. Black personally, draw conclusions based on that examination, and defendants have been denied that similar opportunity due to the protests by plaintiffs of even taking Mr. Black's deposition and allowing any access to him at all. So because both his testimony is formed based on evidence that defendants have not been able to have access to, and because Dr. Martell doesn't offer any testimony that could possibly be relevant to the issues before the court today, we suggest that the court dispense with that testimony and move on to the witnesses that will actually make an influence over the court's decision.
I'll hear from the other side.
Your Honor, Dr. Martell is not being offered as a witness to testify about Mr. Black's competency to be executed. Rather, the defendants have made an issue of the pleadings in this case and indicated that Mr. Black, according to them, should be held to a higher standard of pleading than most people in Tennessee. So Dr. Martell is being offered to rebut their position with respect to what Mr. Black should have been able to plead in the complaint with respect to his pacemaker. So Dr. Martell will be testifying as a result of his evaluations of Mr. Black over the course of the last 5 years with respect to his intellectual and major neurocognitive disorders and how that affects his ability to express language and to speak to counsel.
So the proof is expected to be more narrow than the submission that was made in writing, and that we're not going to venture into questions of whether Mr. Black is competent to be executed. Is that what you're saying?
Yes, Your Honor. Dr. Martell is not going to offer any opinions about competency at all. He's only going to give the court information as to Mr. Black's intellectual functioning and his major neurocognitive disorder and the ways in which that impacts his ability to use expressive language.
As to, you'll definitely get another chance, counsel. As to the question before the court, as I understand it, the only issue before the court is whether this device, and that's about as well as I can describe it, will be deactivated shortly before or at the same moment that the lethal injection is proposed to be administered. Isn't that the only issue before the court?
That's the only issue that plaintiffs presented before the court, Your Honor. However, defendants have defended against our position, saying that the court doesn't have the authority to grant any relief on Claim 1.4 because the complaint itself uses the word pacemaker and does not use the phrase implantable cardioverter, cardioverter, defibrillator. An ICD, as Dr. Van Norman will testify, does have a pacemaker function. It also has a defibrillator function. But the defendants have made it an issue that pacemaker is the language in the complaint and allege the court doesn't have authority over the complaint because of the use of the word pacemaker. So they've put this in issue.
I'll hear from the other side.
Your Honor, just to clarify, the defendants have not said that the court lacks jurisdiction because of the use of the term pacemaker in the complaint. They have simply noted Black's delay in bringing this claim timely to the attention of the court. The facts about which the papers argue before the court in terms of the tactical delay are undisputed. The record's very clear about what was filed, when it was filed. Dr. Martell doesn't have anything to offer on that point. And I guess I'll add to my objection, hearing from Ms. Henry that Dr. Martell isn't going to offer any opinion about competency to be executed, that now we're being presented with what I expect will be a brand new opinion, which was never disclosed in Dr. Martell's expert declaration. The declaration that was filed includes a report dated August 25th, 2020, a supplemental report dated December 13th, 2021, and a report dated May 27th, 2025, and Dr. Martell's CV. None of those, by logical operation of the calendar, could have anything to do with anything about inclusion of pacemaker in the complaint. They all relate to the competency to be executed proceedings. So if we're not going to hear about competency to be executed, we're going to hear brand new testimony from a witness that defendants have had no opportunity to prepare for. I can say, if he gets on the stand, we will attempt to make a showing. We'll have to go through his medical records, put those into evidence. We may be pulling jail calls to play for the court. We can get into that sort of sideshow, but it's not relevant to the court's decision today.
Of course, we wouldn't have to get into this if we agreed that under Rule 8.06, the pleadings ought to be construed so as to do substantial justice, and because this inmate's in his complaint with the assistance of his counsel said pacemaker rather than the actual name of the device, we wouldn't be here. So this is what I'm going to do. I'm going to hear this. I hope it's not very long if it's on a narrow issue. I'm going to allow you to reserve every objection imaginable, even apart from him saying his name. And that'll be reserved, and we won't have to go through that. And that you object on every question that's going to be, so that will be preserved for the record. And maybe we can get through this part quickly and go on to what's next. All right? Does that work?
Understood.
Okay. All right. You may come up, sir. Watch your step.
I do. Thank you.
Good morning, Dr. Martell.
Good morning.
State your name for the record and please spell your last name for the court reporter.
My name is Daniel Martell, M-A-R-T-E-L-L.
And Dr. Martell, how are you employed?
I'm a forensic neuropsychologist.
How long have you been a forensic neuropsychologist?
30-some years.
And as a forensic neuropsychologist, have you testified in any courts?
I've testified many times all around the country over the last 30-some years.
And have you always been accepted as an expert in neuropsychology?
I have.
Have you testified in the courts of the state of Tennessee?
Yes.
And have you testified on behalf of the state of Tennessee in criminal proceedings as a forensic neuropsychologist?
Yes.
Which ones?
Well, there have been many. Two that may be most relevant to these proceedings would be the Coe case. It was Robert Allen Coe and Paul Reed.
And have you been accepted as an expert witness in the state of Tennessee?
Yes,
Do you have a curriculum?
I do.
Your Honor, may I have first witness?
Yes, you may.
Would you also like copies of exhibits?
Please.
Dr. Martell, I'm handing you a document that I should ask the court. How do you prefer to have documents marked with them identified first?
Yes, identify first, and then we'll mark it in sequence. defendants.
Thank you, Your Honor. Could you identify that document for us, please?
This is my current curriculum vitae.
And does that curriculum vitae fairly accurately summarize your professional expertise in the field of forensic neuropsychology?
It does.
And would, Your Honor, I would move into admission Dr. Martell's curriculum vitae as the next member.
I'll hear from the defendants.
Notwithstanding the prior objections, we're going to be able to see.
All right. Exhibit 1 would be the curriculum vitae submitted into evidence based on the statements of counsel for the defendant, preserving the prior objection, but not particular objection as to the contents of this exhibit.
Dr. Martell, have you been accepted as an expert in courts throughout the country on the topic of intellectual disability?
I have.
And did you in fact testify for the Commonwealth of Virginia in the case of Daryl Atkins?
I did.
Your Honor, based on the testimony of Dr. Martell and his curriculum vitae, I would be accepted as an expert in the field of forensic neuropsychology.
I'll hear from the defendants.
Again, subject to the foregoing objections, we're going to object to Dr. Martell being qualified as an expert in this field.
All right. Dr. Martell will be accepted as an expert witness in his field, subject to the broader objections lodged with the court by the defendants. Go ahead.
Thank you, Your Honor. Dr. Martell, we're going to move this along. So I'm going to ask you about your particular involvement in the case of Byron Black. Have you met Byron Black?
Yes, I have.
Have you had an occasion to evaluate, conduct a forensic neuropsychological evaluation of Byron Black?
I have on 2 occasions, the first in 2019 and the most recent one 2 months ago in May of this year.
And during the course of conducting your evaluation of Byron Black, did you prepare and sign expert witness opinions on behalf of Byron Black's legal team?
I prepared reports.
And did you recently provide us a declaration attesting to the truth and validity of those 3 reports?
Yes, I did.
Your Honor, may I approach the witness?
Yes.
Dr. Martell, I'm handing you a document. Can you identify that document to the court?
This is my declaration with my 3 reports attached.
And did you sign the declaration on June 2025?
Yes, I did.
And are the contents of the declaration as well as the appendix reports true?
They are.
Your Honor, I move addition of the declaration of Dr. David Martell as the next member exhibit.
Objection.
The same one we had at the outset, Your Honor.
All right. This exhibit will be the next one to exhibit with the statements and the broader objection we noted for the record.
Dr. Martell, will it assist your testimony to have this declaration and reports in front of you as we go through your examination?
It would be nice if I need to refresh my recollection.
Your Honor, I would request that you be permitted to refer to this.
Any objection?
No, Your Honor.
Thank you.
It's distraction.
You may proceed.
Dr. Martell, back in 2020, when you first evaluated Mr. Black, can you please describe your testing protocol for this work?
I saw him actually in 2019.
I'm sorry.
That's okay.
Excuse me, Your Honor. If we're going all the way back to 2019 and 2020, again, object to the scope of your report going way beyond anything that could be possibly relevant to this motion, which was filed a few weeks ago.
What do you say, counsel?
This is relevant because it provides the testing material upon which we're providing information to the court about our client's intellectual and functioning and brain damage.
I prefer to treat it as background.
Yes.
Let's get to something more clarification.
Dr. Martell, in 2025, did you conduct another neuropsychological evaluation of Byron Black?
Yes, I did.
And did you rely in your evaluation in 2025 on the data that you had obtained and evaluated Mr. Black in 2019?
I did.
And did you take that, and while we talk about that, let's just go to your 2025 evaluation. In 2025,
I administered, the purpose was to see if anything had changed from when I saw him in 2019. We call this serial neuropsychological assessment. So I re-administered a subset of the tests that I had given originally to look for any changes in his cognitive abilities.
So prior to coming to see him this year, when you conducted your contemporaneous evaluation, based on the testing that you had completed in the past, have you already come to some conclusions as a forensic neuropsychologist about Mr. Black's intellectual functioning?
I had.
And what were those conclusions?
That he suffers from intellectual disability.
And what standard did you use to conclude that he has intellectual disability?
I relied on the DSM-5, the Diagnostic and Statistical Manual of Mental Disorders, 5th edition, as well as the AIDD criteria.
And with respect to that criteria, when you saw Mr. Black in 2025, was there anything in your testing that changed your opinion about Mr. Black's intellectual functioning?
No, it reinforced it.
So as we sit here today, do you have an opinion to a reasonable degree of neuropsychological certainty as to whether or not Mr. Black is a person living with intellectual disability?
I do.
And what is that opinion?
He is.
And what do you base that opinion on?
On the testing, the history, my clinical examination, my reliance on other doctors who did comparable things over the years, and we all converge on the same answer.
And did you list the materials that you relied upon in your 2020 report as well as your 2025 report?
Yes.
Your Honor, I'm not going to go through all of those. Those materials, as are reflected in Dr. Martell's report, are already in the record attached to our memorandum in support of preliminary injections. So for purposes of shortcutting, those are already in the record as declarations, but we're just going to move straight to 2025 if that's okay.
Thank you.
So with respect to your testing in 2025, you did perform the neuropsychological battery, is that correct?
I did.
And can you just describe to the court what a neuropsychological battery is?
So it's a collection of tests that each tap different neurocognitive domains: memory, attention, language abilities, constructional abilities, things like that, executive functioning, higher level cognitive abilities.
And did you draw any conclusions? And you had done a full battery back in 2019, is that correct?
Yes.
And in 2025, when you conducted this subset of tests in your neuropsychological battery, did you come to any conclusions about Mr. Black's neurocognitive functioning in addition to your conclusion that he has intellectual disability?
I did.
Can you please describe those conclusions for the court?
Well, to make it brief, he now has dementia, what we call a major neurocognitive disorder. He probably had it before, but his neurocognitive abilities have deteriorated significantly over the 5-year period, to the point where he went from maybe the 16th or the 10th percentile down into minuscule 1 in 1,000, 1 in 10,000 levels of impairment in language, executive functioning, and memory.
What does that mean for Mr. Black in terms of his everyday functioning with respect to his language skills?
Well, this severely limits his ability to communicate effectively. He's certainly able to hold a conversation. He's a likable, affable gentleman, but he's unable to find words that he needs to express himself. He can't access them. If you show him a picture of a wreath, he cannot come up with the word for what that is, for example.
Your Honor, if you'll just give me one moment to consult your request. Thank you, Your Honor. That's all the questions I have.
All right. Cross-examination.
Morning.
My name is Cody Brandon. I'm an attorney for the defendants in this case, for the Tennessee Attorney General's office. I don't believe you and I have the privilege of meeting before, have we?
I don't think so.
I am just going to ask a few questions that would like to clear up on your testimony earlier. You testified that your assessment of Mr. Black was made earlier this year in May. I think it was the last time you had an opportunity to physically examine Mr. Black.
That's right.
At that time, the request for the examination related to evaluating his competency to be executed, correct?
I don't think that was my specific referral question. My recollection is there was another expert who was taking on that issue, but I was asked to do testing that might support her opinion.
If we could look at your third report dated May 27, 2025,
I have it.
and paragraph 5 on the first page, referral questions. At common law, an individual's categorically exempt from execution if he or she is found to be non-compos mentis. Does Mr. Black meet the following criteria for non-compos mentis? That question that you answered with respect to Mr. Black is specifically related to his competency to be executed.
It was. That was unique. I was thinking forward incompetency, which I did not evaluate, but I was asked to address that, yes.
Dr. Martell, in your evaluations, did you review Mr. Black's medical records?
I did.
I'm going to show you a few documents from those records. If I could look through them here. The first is what I've marked for identification as defendant's exhibit AA. Your Honor, if I could share
You
these.
may approach.
Excuse me, Your Honor, I might object.
Excuse me.
I have an objection to
Go ahead.
this exhibit. AA, Your Honor, this is an exhibit which is a medical power of attorney. I'm sorry, authorization for release of health services information. Mr. Black signed in 2018. Again, this is a document from 2018 prior to 2025. Evaluation of Mr. Black, consistent with this court's ruling. I limited my questioning of Dr. Martell to his contemporary evaluation with background information. So release of information signed in 2018 is stale.
Your response, counsel.
Your Honor, I believe Dr. Martell, in response to Ms. Henry's questions, said that his opinions were formed based on the earlier evaluation, review of medical history, and his observations of Mr. Black changing over time in 5 years between his evaluations. If we're going to accept Dr. Martell's testimony and allow it in the record, ask that we allow the cross-examine him very briefly on these medical records, which inform his opinion.
All right. Objection overruled. Go ahead.
And Doctor, as Ms. Hendricks just stated, the top of this document reads authorization for release of health services information. And if you could look down at the bottom under offender's signature, tell me if you recognize the name there.
I do.
Whose name is that?
Mr. Byron Black.
And just above his signature, there is a paragraph in bold and italics. I'm going to read it, and you correct me if I get it wrong here. It says, if the subject is not legally competent to sign or is unable to sign, authorized representative, a legally appointed conservator, guardian, or attorney in
did.
And Mr. Byron Black signed that, not a durable power attorney or other agent acting on his behalf.
That's right.
All right, Dr. We're going to move to what's been marked for identification as defendant's exhibit B.
Let's get to A. Do you want this offered into evidence or just want for identification?
If we could move it in, I'd appreciate that.
Any objection?
Only my previous one, Your Honor.
All right. Subject to the prior objection, Exhibit 3 is submitted to evidence.
Your Honor, if I could approach it.
Yes, you may.
Your Honor, like if I just approach the user, or I can ask permission.
You've got continuing permission, but sometimes lawyers want it on the record. It's up to you.
All right, Doctor, I handed you what is marked as defendant's exhibit B. If you could turn to the second page of that exhibit and read again the title of that document.
Authorization for release of health services information.
And then on the second page, you can see a signature down on the bottom under, or above offender signature.
I do.
Whose signature is that?
Mr. Byron Black,
And what's the date of that signature?
9/24/2019.
And just above that signature, there's the same paragraph again. I'll paraphrase this time. If the subject is not legally competent to sign or is unable to sign, authorized representative must sign this authorization. That's the same as we just read the last time.
It is.
And Mr. Byron Black signed that in that paragraph, didn't he?
He did.
Are you offering this?
Yes, Your Honor, that'd be the
Your objection?
Same objection, Your Honor.
All right. Exhibit 4 is admitted over the objection. Go ahead.
Doctor, I'm going to hand you what's been marked as defendant's exhibit B for identification. Doctor, again, with that in hand, could you read the title of that document?
Authorization for release of health services information.
And you see a signature again under, above offender signature at the bottom of that page.
Yes, I do.
Whose signature is that?
Byron Black,
And what's the date of that signature?
May 20, 2000.
Sorry, what date was, what year was that?
Oh, maybe it's 2020. I'm sorry. Yeah.
Dr. Martell, does this form contain the same paragraph that if the subject is not legally competent to sign or unable to sign, the authorized representative must sign this authorization?
It does.
And Mr. Black signed that authorization as well.
Yes, he did.
I ask that that be admitted as the next exhibit.
Any objection to Exhibit 5?
Same, Your Honor.
All right. Exhibit 5 is submitted over objection.
All right, Doctor, I'm going to hand you what I've marked as defendant's exhibit FF for identification.
problem-oriented progress record.
And that's a document that's on Tennessee Department of Correction, letterhead, I guess, has a title there.
Yes.
We could turn to the second page of this. You see the paragraphs that appear in the notes there in that progress record.
I do.
And what is the first date of those notes in the left column?
On my copy, the month is cut off, but based on what appears further down the paragraph, I would say it's October 29th, 2020.
And in the paragraph of the notes there, the third sentence starts with he denied.
Excuse me, Your Honor, if I might object. This is a hearsay document, and there's no proof of foundation or authenticity as to the nurse practitioner who summarized Mr. Black. No quotation marks from Mr. Black in this document, and I think it's admissible for the treatment matter, sir.
Yeah, this is a document provided by plaintiffs in response to request for production. It would bear a date stamp if it was produced and authenticated as part of Mr. Black's medical records. And Dr. Martell has already testified that his opinion was informed by Dr. Black's medical records. This goes to the quality and credibility of his opinion and the effect that that information that he would have in contributing to his opinion.
I don't see a lot of appropriate value to it, but we'll allow Exhibit 6 to be admitted as evidence.
Beginning of the doctor with the third sentence, I guess I'll start with the second sentence. The note reflects that Mr. Black came to appointment with one person assistance,
It does.
and then the sentence following that, he made Mr. Black deny any urinating difficult or frequent urinating.
Correct?
He also denied short of breathing.
Correct.
He stated he gained a lot of weight because he ate a lot more than before.
That's right.
He admitted that he was drinking a lot of fluid daily.
He did.
He complained about right hip pain.
Yes.
He also described taking Lortab, QAH, PRN almost
Your Honor,
every
let me
dose.
object because that is a misstatement of the document. He takes Lortab, very well just be the nurse noting what Mr. Black is taking, not.
That's fine, I'll move on from that question.
I don't see a reason why we go through all this. It's in evidence.
That's fine, I can move on for time purposes. Doctor, it's Mr. Black in this progress record, in all of the details that we'll move past, provided a number of detailed statements about himself and his medical care to the person taking the notes.
I didn't hear the end of your question.
Mr. Black, in his progress record, reflects that he provided detailed information about his medical condition to the person taking the notes.
He did. I mean, it's basic information. I don't know how detailed it is.
Doctor, I'm going to show you I think that's already been moved in evidence, the previous exhibit. I just want to make sure that we're ready for it.
You know, this document that we're talking about now?
Yes, the progress record.
Yes.
Okay. We'll move on then to what's been marked for identification as defendant's exhibit HH. Doctor, in your hand marked as defendant's exhibit HH, could you read the title of that document?
Authorization for release of health services information.
And do you see a signature of offender signature
I do.
Whose signature is that?
Byron Black,
And what's the date next to that signature?
March 3rd, 2022.
And like similar authorizations we discussed before, there's a paragraph above the signature reflecting that if the subject is not legally competent to sign or unable to sign, the authorized representative must provide authorization.
Correct.
And Mr. Black signed that document.
He did.
Your Honor, I ask that be admitted as the next number exhibit.
Same objection. Exhibit 7 is admitted over the objection.
Doctor, I'm going to approach with what's marked as defendant's exhibit MM. Doctor, if you could read the title at the top of that document.
Authorization for release of health services information.
And you see a signature of a offender's signature at the bottom of the page.
I do.
Whose name is that?
Mr. Byron Black,
What's the date of that signature?
9/15/2022.
And there's a paragraph above that's the same as the paragraphs we read before, that if the subject is not legally competent to sign or unable to sign, the authorized representative must sign the authorization.
There is.
And Mr. Black signed that document.
Yes.
I ask that that be admitted as the next exhibit.
Exhibit 8 is admitted over the objection. So, counsel for sign.
Doctor, I'm going to show you what's been marked right application as defendant's exhibit NN.
Without going into any details, we might need some redactions on exhibits 3 through 8.
Your Honor, we could work that out during the break, if that's all right.
No need to stop. We'll take care of that later. I don't want it to be noted.
Dr. Martell, if you could look at what is marked right application as defendant's exhibit NN and tell me the title of that document.
Durable power of attorney for healthcare.
And in the first paragraph under designation healthcare agent, it reads, I, Byron Lewis Black, appoint Kelly J. Henry, supervisory assistant federal public defender, 810 Broadway, Suite 200, Nashville, Tennessee, 372-3615. I'll swear to God here, as my agent to make any and all healthcare decisions for me, except to the extent I state otherwise in this document. The durable power of attorney for healthcare takes effect if I become unable to make my own healthcare decisions, and this fact is certified in writing by my physician. Did I read that correctly?
You did.
Have you seen any documents in Mr. Black's medical records where consents are signed by Kelly J. Henry, supervisory assistant for the public defender, instead of Mr. Black?
No.
Have you seen any documents in Mr. Black's medical records certifying in writing by his physician that he is unable to make his own healthcare decisions?
No.
If you could flip to the second page there, Doctor, there's a signature in the middle of the page. Do you recognize that signature?
I do.
Whose is it?
Byron Black,
And what is the date of that signature?
August 19, 2022.
And to your knowledge, Kelly J. Henry, Supervisory Assistant Federal Public Defender, is that counsel for the plaintiff that's before her today?
As far as I know, yes.
I asked about the admitted as the next number exhibit.
Exhibit 9 is submitted into evidence over counsel for plaintiff's objection.
I'm going to show you what's been marked for identification as defendant's exhibit PP. Here at the top of that exhibit, it looks like there's some splotches, I guess, on the exhibit, but best as you can make out. What's the title of that document?
Advance Directive for Healthcare.
And under agent, the document reads, I want the following person to make healthcare decisions for me. This includes any healthcare decision I could have made for myself if able, except that my agent has followed my instructions below. Did I accurately read that?
Yes.
And who is the person designated as the agent on that form?
Your Honor, I'm sorry if I can object. I do not object to the fact that Mr. Black has filled out various advanced directives for healthcare, and I do not impugn the credibility of the state that this document is not the original. Page 2. Does not contain some information, signatures of which I am not aware, and I am aware that page 1 of this document, as well as page 3 of this document. So this is not the complete original. And so this witness cannot authenticate this document. I'm just telling you this is not the document. I don't know what to do about that.
Yeah, did you have the original to produce?
The original was given to Riverman Maximum Security Institution at the time it was signed. He signed a few of these over the years at my request. I have no idea what Riverman does with their records and their record keeping, but this is not a complete full document. Dr. Muoza was not present when this document was signed.
So let's mark it for identification purposes as you should.
Doctor, sorry, forgive me if I've asked you this already. Who is the agent designated on this one?
Arleta Swanson.
And an alternate agent is also designated. Who's that agent?
Melba Corley.
On the second page, there's a signature, and your signature, and above the word patient. Do you recognize that signature?
I do.
Whose is it?
Byron Black.
And what's the date of that signature?
March 14th, 2023.
And in your review of Mr. Black's medical records, have you seen any consents or other forms signed by Anita Swanson instead of Mr. Black?
Not that I recall.
And any by Melba Corley?
No.
The when effective on this advanced directive asks the signer to mark the box. The first box says, I give my agent permission to make healthcare decisions for me anytime, even if I have capacity to make decisions for myself. Is that correct? On the first page, it's like up here, towards the top, above the first black line.
Yes, I see that.
If I could just have 1 minute to
You may.
blacklist, we just have to.
Of course.
I guess I can take that while we look at that exhibit. I asked, I have additional questions for Dr. Martell. This will be my last in relation to this exhibit. There are some audio files that I'm having technical difficulties being able to present to your honor right now. I just asked that the doctor be subject to your call if it's necessary to call and show you this exhibit at a later time.
We don't have all week. I'll allow some leeway, but audio files and all that, you know, we need to get to the issues at hand.
Understood, Your Honor.
I understand.
Consonant with my objection, but
I know you're trying to, I know you got leeway on cross-examination and all that, but let's get to it.
I apologize if Your Honor will be patient with me for just 1 minute. I'm trying to find page 100 out of 300 pages of documents that are not labeled with page numbers.
Take your time. I want you to get the right document. Counsel, if you want a short recess, I'm available.
I think that might be appropriate.
All right.
Oh, thanks.
Let's take it.